not. So we were able to bring him with a last minute notice, that's why. Yeah, definitely. Thank you so much. Unfortunately, I don't have my card. Very nice meeting you, Barbara. We met with the ambassador a year and a half ago when he arrived in Cyprus. We had such fun that night, but unfortunately we didn't have the chance to see each other again. I have a Spanish client. I work in marketing and strategy and stuff. Sarah Group are my client, so that's why we had the meeting. We started working for the election, so the outings are reduced after the election. Thank you very much for coming. Please do come as well. Please.
Dear guest, we would like to welcome you on our tonight's event, which we will be discussing the issues, the effects, or let me better say the side effects of the exit of Britain from the European Union.
Πες μου για να του δώσω το... Θα σας δώσω τα 30 δευτερόλεπτα, τα 10. Σε 30. Σε 10 δευτερόλεπτα.
Αγαπητοί προσκεκλημένοι, θα θέλαμε να σας καλωσορίσουμε στην απόψινή μας εκδήλωση με θέμα την έξοδο της Μεγάλης Βρετανίας από την Ευρωπαϊκή Ένωση και το τι αντίκτυπο θα έχει σε εμάς ως Κύπρος σε σχέση με τις Βρετανικές βάσεις. Dear guests, I would like to welcome you to our tonight's event, which we will be discussing the effects, or let me better say the side effects, of the exit of the European Union from the European Union. Our distinguished speaker tonight is Professor of International Law, Mr. Alain Pellet. Thanks very much for coming, Professor. Mr. Pellet is an emeritus professor of Nanterre University, Paris. He's a former member and former chairperson. He is also a member of the International Law Commission of the United Nations, designated to the panel of arbitrators of the ICSID and to the list of arbitrators of the United Nations Convention of the Law at Sea. His academic qualifications are endless. Degrees of public law, political studies, political science, doctorate of public law, etc., etc., etc. He also has a very long publication record with important contributions to the science of the international law. Tonight, Professor Alain Pellet will analyze to us the effects, let me better repeat or say, the side effects of the Brexit in relation to the British sovereign base areas in Cyprus. He will be referring also to the case of Gibraltar, and I expect that he will analyze to us whether we have an opportunity in front of us or not. My dearest Professor, the floor is yours.
Thank you. It works? Yeah, this one. Thank you very much. I thought I will come after my friend Elike, so it comes as a surprise, but I have to speak first. Well, exorismoi, Kyrios kai Kyrioi, agaritoi philoi, kalo gradi. Unfortunately, it will be the only words you will hear from me, and I am not sure that they are real Greek. I learned Greek when I was at school, but unfortunately it was ancient Greek, and I have forgotten everything. So I'm afraid that you have to endure my English. Before dealing with this evening topic, let me tell how grateful I am to my good friend Yorgos Lilikes to have created this occasion to renew with Cyprus, a country with which I have very ancient links, and which still makes me the friendship and honor to consult me from time to time on legal issues, and I insist on legal issues, and I am not sure that I quite recognize myself in the nice description which was given to you. I am a pure lawyer. I have never really written in international relations. The only thing I can do is really to deal with legal topic, and I have this afternoon for lunch. I was kindly invited by President Lilikes, and we discussed a bit on the topic, this evening topic, and I must say that as you will probably see, except if I can convince him right away, we have probably some difference on today's topic, because he will speak as a politician. I can only speak as a pure lawyer. As a politician, I think that his conviction, again I thought that I would speak second, is that Cyprus should and could try to take the opportunity of the Brexit to change the regime of the British bases. He might be right. However, as a lawyer, I cannot help to think that both issues, the Brexit on the one hand and the so-called SBAs, the so-called sovereign bases, British bases, have in fact little in common. And let me make a last preliminary remark. I must pay tribute to President Lilikes' open-mindedness. He has invited me without sounding me at all on what I was going to say, and when I summarized my position today around the excellent meal he had invited me to, he has not at all tried to influence or to change my mind. Now, it is true that if we can differ on the opportunity afforded by the Brexit, we certainly share the same opinion on a much more important and crucial topic or point, which I had developed in 2011, I think, 10. So in 2010, and the main point of my speech at the time was that the SBAs are in themselves a rather, I would say, shameful and illegitimate and unlawful remnant of the colonial past of this country. Well, now, this all being said, I can turn to the topic of this evening, a topic which was assigned to me and of which I'm absolutely not a specialist. I'm not a specialist of nothing. I just try to have some ideas on international law. So the British sovereign base areas, I will call them the BSAs, in Cyprus after Brexit. As you know, the result of the referendum held in the United Kingdom on 23 June 2016, which favoured withdrawal from the European Union. I think, honestly, I hope that there is no representative of the British embassy here, but I think that it was a crazy decision. Although personally I favoured it, because I think that Europe will be better, in better shape without England than with it. Anyway, on the vote on the Brexit mark, I think, the entry into a new legal and political context, which will unavoidably have important consequences and which, as has been written, immerses us in a turbulent sea of doubts. It also certainly creates new opportunities. The burning question that my esteemed friend Yorgos Lilikas raised in our exchanges is, how could Cyprus take advantage of the Brexit and modify the status of the British sovereign base areas, the SBAs? And I think that this question is the logical follow-up to the one put by Lord Anderson of Swansea before the House of Lords 2 years ago, without any relation with the Brexit. How is that the guarantor power status, post-colonialism and post-1960, still appears relevant when it is not, and Cyprus is now a full member of the European Union? With regard to the renegotiation attempts as a consequence of Brexit, the example of Spain immediately comes to mind. Spain, just after the Brexit was voted by the Brits, Spain immediately invited the UK to resume talks on a joint sovereignty agreement over Gibraltar to ensure that the provisions of the EU treaties continue to apply, with both states taking responsibility for defense, foreign relations, border control, asylum and immigration. All other competences, according to the Spanish proposals, would belong to Gibraltar itself, whose population, moreover, would be guaranteed a personal statute that maintained their British nationality and also which would facilitate access, if so desired, to Spanish nationality. The rationale of the Spanish proposals is that, and I quote from the declaration of Spain to the Decolonization Committee, so I quote, "Under the European treaties, a British exit, Brexit, would also imply the exit of Gibraltar, marking a radical shift in the territory's relationship with Spain and entailing significant consequences for Gibraltar, whose economic model was based on full participation in the European Union internal market, and for the adjacent Spanish district of Campo de Gibraltar, whose economy was closely interconnected with the territories, given the major presence of Spanish workers in Gibraltar itself. And I think it is a good description of the problem which arises for Gibraltar in relation to the Brexit. And I must say, en passant, that I am also a legal advisor for Gibraltar, for which I have worked a lot, and I still do. I take my But the so-called British sovereign base areas in Cyprus, I think, do not compare to Gibraltar. First, I will reiterate what I had already said in 2010, and also as I have just recalled, the British bases are not sovereign. They are an anomalous remnant from the colonial past, but they are parts of the Republic of Cyprus, legally speaking. Their particular situation, and it is a particular situation, as the 2003 third protocol on the sovereign basis puts it, is related and only related to the non-economic nature of the British presence in Cyprus. Moreover, it is true that both parties could renegotiate the aspects of the 1960 Establishment Treaty relating to the SBAs in order to modernize the rules applicable to them, to clarify some aspects, for example, regarding the maritime rights of the British parties, on which I have still rather strong feelings, but I have explained myself at length during my previous speech in 2010. And also negotiations could easily fill some gaps in the protocol. Probably a good starting point might be the renewed offer by the British government to relinquish part of the SBAs having no use for military purposes, and I think it would be totally in line with the very idea of the so-called sovereign basis. The UK has renewed its opportune offer. But I think two things must be noted. First, the proposal to surrender nearly half of the landmass of the SBA territories was first made more than 10 years ago without, to my knowledge, any concrete effect. And second, the renewed offer was made in 2015 as part of a proper and comprehensive settlement of the Cyprus question as a whole. In the, said the British representative, in the hopeful event of reunification, and it has been described as an offer to help Cyprus Turks. And nothing is said in relation with the EU or, of course, with the Brexit there. This being said, I would think that even if the negotiations to that end were to be successful, I'm not sure that the success is for tomorrow, the main issue would remain. It does not bear upon the extent of the SBAs. I think the real question is a matter of principle. Is the very status of the so-called sovereign bases acceptable under today's international law? There is indeed no legal objection at all against accepting some kind of military bases on this territory of Cyprus or of any state. But to consider them as under the sovereignty of the country which manages these bases is totally another question. Again, contrary to Gibraltar, the SBAs are not non-self-governing territories within the meaning of the UN Charter. On Gibraltar and its other non-self-governing territories, the UK has to report to the UN Decolonization Committee, and I want to recall that reporting to the UN has been instituted with a view to protect the population of the territories in question. Yet the SBAs have no population properly set. Indeed, and you know this better than I do, but indeed they are inhabited, but only by two categories of persons. On the one hand, if my figures, which date from last year, reviewed by the headquarters of the SBA administration and British forces in Cyprus. So last year, I think that the British inhabitants are around 8,000, including 3,140 military personnel, as well as civil servants, contractors and their families. And on the other hand, the 11,000 Cypriots living in the areas are recognized residents of the SBAs, but are ROC and EU citizens. Both categories of inhabitants have, as I said 7 years ago, had their natural protectors, the UK for their militaries and Cyprus for the Cypriots living there. Besides, the SBAs cover around 256 square kilometers, which are mostly, I think about 60%, privately owned by Cypriot nationals. In 2014, the UK and Cyprus signed an arrangement to further develop private property within the SBAs and to adjust certain elements of the 1960 regime. The said arrangement indeed notes and balances, I would say, the strongly expressed desire of the residents of the SBAs for greater flexibility in relation to non-military development on the one hand, and on the other hand, the UK's key policy objectives in administering the areas on the other hand. And I recall that the objectives of the UK policy here are first an effective use of the sovereign base areas as military bases, and I insist again, military bases. This all is just was said that the three aims were described in the declaration by the UK government regarding the administration of the sovereign base areas in 1966. So first, effective use of the SBAs as military bases. Second, full cooperation with the Republic of Cyprus. Third, protection of the interest of those resident or working in the SBAs. End of quote. Finally, I also wish to recall that while the legislation in the SBAs is made by the administrator of the bases, it mirrors in general today the ROCs, the Cyprus laws in line with the UK's declaration of 1960, according to which, and I quote, the laws applicable to the Cypriot population of the sovereign base areas will be as far as possible the same as the laws of the Republic. And since the laws of the Republic are now in line with those of the EU, of the European Union, by this indirect means, EU law is part of the law applicable in the SBAs. Now, turning to the status of the SBA under EU law precisely, the UK's Treaty of Accession to the European Communities provided that the treaties, and I quote, shall not apply, the not is really important, shall not apply to the sovereign base areas of the United Kingdom in Cyprus. However, an annexed joint declaration, which was adopted by the plenipotentiaries which negotiated the Treaty of Adhesion, and the Council affirmed that, and I quote, the arrangements applicable to relations between the EEC and the SBAs of the United Kingdom of Great Britain and Northern Ireland in Cyprus will be defined within the context of any agreement between the community and the Republic of Cyprus. Hence, it is with the Act of Accession of Cyprus in 2003 that the relations between the EU and the SBAs were eventually defined. In its preamble, Protocol number 3 recalls the rights, protocol to the Act of Accession, recalls the rights and obligations of the parties to the Treaty of Establishment, which are not to be affected by the accession of Cyprus to the EU, and recognizes, and I quote, the need to apply certain provisions of the treaty establishing the European Community and related EC law to the sovereign base areas, and to make special arrangements regarding the implementation of these provisions in the sovereign base areas. Article 1 of still Protocol 3 provides that, and I quote again, Article 299 6b of the treaty establishing the EC, which is now, I don't think it's very interesting for us, but now Article 355 5b of the Treaty on the Functioning of the European Union, so shall be replaced by the following, and this is a more important quote, the treaties shall not apply, again negative, to the United Kingdom sovereign base areas of Akrotiri and Dhekelia in Cyprus, except to the extent necessary to ensure the implementation of the arrangements set out in the protocol and in accordance with the terms of the protocol. In other words, the adhesion does not change the status of the sovereign basis, the so-called sovereign basis. And it follows that the SBAs are not formally parts of the EU, contrary precisely to Gibraltar. The latter, Gibraltar, indeed falls under the Article 355 of the Treaty on the Functioning of the EU, according to which the provisions of the treaties shall apply to the European territories for whose external relations a member state is responsible. Since the UK, in charge of Gibraltar's external relations, will lose its membership, EU law will no longer be applied in the colony. The connection between Brexit and the SBAs appears to be less intimate and, in a way, maybe more intricate. Indeed, while the SBAs remain outside the EU territory, Protocol number 3 nevertheless acknowledges the open boundaries and creates a sui generis regime entailing the limited application of EU law, mainly with regard to customs, to taxation, to agriculture, to social security. I hate the expression sui generis, but lawyers, when they say sui generis, means they don't really know what they are saying. But this status is so special that I think everybody, and certainly myself, accept that in that specific case, it is sui generis. Article 2.1 notably provides that the SBAs shall be included within the customs territory of the community, now the EU, and for this purpose, a list of customs and common commercial policy acts apply, subject to certain amendment. But again, it does not make the SBAs part of the EU. As to accept, if we accept that they are part of the Republic of Cyprus, but this is the other, for me, another question. For the moment, they are considered by the EU law, and I think for bad reasons, but they are considered by the EU law as not being part of the EU itself. As to the division and possible delegation of competences between the UK and Cyprus, Protocol number 3 takes note of, quote, the arrangements made pursuant to the Treaty of Establishment, whereby the authorities of the Republic of Cyprus administer a wide range of public services in the sovereign base areas, including in the fields of, still the same, agriculture, customs and taxations. And indeed, the base areas of Akrotiri and Dekelia are treated as part of the territory of Cyprus for customs, VAT, and excise purposes, and they have been de facto member of the Eurozone since Cyprus adopted the Euro in 2008. If you speak of the de facto, this afternoon I visited the part of Nicosia which is occupied by the Turks. Everywhere you can pay with euros as well, so it is a de facto problem, but it doesn't make the northern part of the Republic quite a part of the Eurozone. Well, anyway, still, the UK is in general responsible for the implementation of Protocol number 3 in these areas. So all the fields I have listed must be considered as exceptions. And the UK is responsible notably for the application of certain EU measures in the fields of customs, of indirect taxation, of the common commercial policy in accordance with Article 7 of the protocol. As regard the eastern sovereign base area and corridor road that links Dekelia to Agios Nikolaos, they constitute, as has been declared by the Secretary of State for the Foreign and Commonwealth Affairs, they constitute a de facto EU external border, bringing immigration and customs responsibilities for the SBA administration. Following the Brexit notification, the European Council adopted last April a specific guideline on the SBAs, stating that, and it is grosso modo, to my knowledge, the main declaration of the EU in relation with the SBAs, in relation between the Brexit and the SBAs. So I quote it, I read it slowly because it is the best we can have from the point of view of the EU. The Union should agree with the United Kingdom on arrangements as regard the sovereign base areas of the United Kingdom in Cyprus and recognize in that respect bilateral agreements and arrangements between the Republic of Cyprus and the United Kingdom, which are compatible with the EU law, in particular as regards safeguarding rights and interests of those EU citizens resident or working in the sovereign base areas, end of quote. And this last expression